So, what are we talking about today?
Yeah, today we're talking about common law couples. I think a lot of questions we've gotten in the past were related to common law couples, and we were really touching on things like the matrimonial home, things that are more directed to married spouses, because there is a difference, and we're gonna deep dive into that today. But yeah, just for everyone watching, you'll notice your screen might be going all over the place. Please bear with us. We're trying to be tech savvy here and go above and beyond and try something new. So
I'm gonna date myself. Remember like the 70s show? They'd have a little no, there's a thing called TV, right? Anyway, so they have different angles and sort of retro, but not retro, but hey, we're live via YouTube. That's something.
that is huge.
That's fun.
It's big, it's a first for us.
Today in person and live on YouTube.
That's right.
And out 3 try.
That's right.
Yeah, it's nice to have all of us in person in the same room,
Yeah.
discussing, make it a little more informal, which is nice, a little more casual of a conversation. I know people at home, they like the casualness of this, so
Yeah.
it's definitely appealing to them.
Well, it's sort of the go back hours, right? Like if we're chit-chatting with a family member or friend, we would explain in their language some of the concepts we're talking about.
Yeah.
And that's sort of our goal tonight, right?
100%. Yeah. Concept throwing around matrimonial home, unjust enrichment, all these
It depends.
well, that one anyone can understand for sure. Even if you didn't go to law school, you didn't do
Sure.
study or practice, but yeah, we'll do our best to. It's hard sometimes to flip that switch when you've been practicing so long, immersed in the legal, language for so long, and you are drafting, like you're typing and you're writing using this language. So sometimes I catch myself. And I always tell clients, I'm like, stop me. Like if I say something that you don't understand, like please stop me.
It's second nature though, it's the language of the business, right? Every industry has industry specific lingo. Yeah.
I try to think like if I'm going to the mechanic, I know nothing about cars. So if they're talking about the axle, that if it's not the wheels, either one, the steering wheel or the wheels on the car, I probably won't know what you're saying. So I
used to change oil when I was in high school at a Canadian Tire pit stop. What a job that was. But you get, the oil filter codes would be burnt in your brain, right? Like a Ford would come in, I knew that was an 04 filter we needed. It's just like any industry, just get used to using this language. The law is not dissimilar to that.
100%. Yeah.
And it's also used pretty, aside from the change in custody and access, the words that we've used, go back a really long time.
Yeah.
Like a lot of things haven't changed.
Well, hundreds of years. Bill Rogers, we're going back, may not be going back to the Crusades, but we could. We're talking about common law, right? And he would.
100%. And nice segue. That is exactly. I see it's 5 o'clock. It's officially after hours. We're just going to jump right into some quick housekeeping. Again, we are trying out a new tech arrangement, so please bear with us. We really appreciate your patience. You will notice that there's no chat feature here, but there is a Q&A box. So if you have any questions or you have any comments, please submit them through that box. Just a friendly reminder, the purpose of this series is to discuss general information on separation, divorce, and other family law matters. So today we are talking about common law couples in Ontario and their legal rights. So no information provided here should be taken as legal advice. If you do want specific answers specific to your matter, please call our office or call a lawyer in your area to book a consultation. And I do believe we have a little teaser. So stay tuned to the end. We may have a way, or we may be providing a code to book a free meeting with one of our lawyers for up to 20 minutes. So just make sure to stay tuned to the end to see.
That's like feedback guarantee. How can you go on?
Yeah, if you, I'll do a share. So, welcome to our free webinar. We want to offer you your money back guarantee. So if you don't enjoy the webinar, let us know. So I'll just get right into introduction.
Let us know if you do enjoy it too.
Yes.
Yes.
I'll sort of reiterate all this at the end, but we love the feedback that we've been getting, feedback on future topics, on what you like, what you don't like, what you could use more of. So make sure to utilize that at the end. So today we have Joseph here. He is an articling student at the firm and is set to be called to the bar in Ontario in 2024. He graduated from Ted Rogers School of Management at Toronto Metropolitan University, formerly Ryerson. And he also attended Queen's University of Law. As he enters into the next phase of his legal career, Joseph, or Joe, is committed to positively influencing the lives of those facing difficult family situations. We also have Shanza.
And he's a Leafs fan.
He is a massive
Yes,
Leafs
ma'am.
fan.
I am a Leafs fan. Big game tonight, 7:30 versus the Devils at home.
Is Marner back? Was he injured? What happened?
Bad ankle injury.
I thought Samsonov got hurt. Yes.
He's fine, he's fine, he's fine, guys, he's fine. Stop putting the voodoo up there. He's fine. Move on past the injuries.
No Leafs, no.
But is also an articling student with us. She's a recent law graduate from Osgoode Hall Law School, and she plans to be called to the Bar of Ontario in June of 2024 as well. She's focused on launching her legal career in family law and is dedicated to providing empathetic and proficient legal support for those navigating family-related complexity. She also has a great deal of experience stemming from active participation in legal clinics, mooting competitions, and prior work as a legal assistant. So as she embarks on her legal journey, she's poised to contribute to the firm's commitment to excellence in family law, leveraging her diverse background and unwavering dedication. We also have Russell here, the founder and senior partner at Russell Alexander Collaborative Family Lawyers. With over 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and help them cope with the difficulties of separation and divorce. Russ has written 4 books. Was there 5th on the way? Not yet, maybe.
Somebody wants us to write a book on impasse, but we'll see.
Okay.
Yeah.
So if you haven't taken a look at any of his books, I strongly recommend. They're great reads. And Russ, as well as all of us, are trained as collaborative practice lawyers. And you can always catch Russ at conferences on collaborative practice, marketing, as well as technology in the law.
The KFC too, right?
KFC.
Good job, eh?
Yeah.
That's right, yeah.
So I'm last but not least. I've been with the firm since 2018. I was called to the Bar of Ontario in 2022, and I'm now an associate lawyer at the firm. So I completed my undergraduate degree at Queen's University, and I obtained my law degree from the University of Liverpool in 2020, graduating with first class honors. And I'm really committed to assisting clients through what's traditionally a very difficult time by approaching matters with empathy, integrity, and compassion. And my word of the year was fearless, so doing that as well.
And you have trials coming in, hopefully you'll be fearless.
Trials, I have
We're
emotions.
doing trial prep today.
Leaving accounts on.
You should have.
Maybe in May, while I'm
See what
mid-trial.
the audience wants.
Yeah. Open the floor. So we'll jump right in. Again, reminder, there is that Q&A box. So if you have any questions or comments along the way, please send them through. We do our best to try to get to all of them. Sometimes they fly in really fast. So again, just bear with us.
Okay, we're asking to get a little bit better sound quality, so we'll just talk a little bit louder. Sorry about that, but we're gonna press on.
Okay. Keep us posted if it gets better or worse.
Yeah, please.
So the first topic we will touch on in our webinar today about common law is the definition. What is common law? How is it recognized legally? Joe, I'm gonna send it your way.
Yes, thank you. So yes, common law in Ontario, what does that mean? Well, common law is a recognized legal form of partnership, as is marriage, and it refers to a relationship status where a couple, man, woman, woman, man, whoever, They live together in a conjugal relationship without being legally married. And in Ontario, all common law relationships are recognized under the Family Law Act, which is a piece of provincial legislation. We talk about it all the time, and we reference it all the time in our work. And there are two ways a couple can be considered common law. The first being that they've lived together for a certain period of time, and that certain period of time in Ontario is 3 years. It does vary by province, so you could affect your provincial legislation. And another way that a couple can be considered common law is if they have a child together. That can be either through birth or through adoption. And as long as there's still a conjugal relationship between the two people of some permanence. And a question that we get often is, what's the real difference? What's the main difference between common law and being actually married? And in Ontario, common law relationships have fewer rights and responsibilities than those of an actual marriage. And while they do have common law marriages, while they do have similar rights, there are several key differences, and that's stuff we're going to be speaking to you guys today about. And unlike marriage, common law relationships do not require a formal ceremony or any type of registration. It's just something that is established. And documentation such as joint bank accounts, shared leases, or any other proofs of cohabitation between the two of you definitely strengthen that claim and that status.
So when does it start? I got my own idea, but let's just do, when would you say it starts?
Roundtable? When would it start? I say it starts when your lives become intertwined. So socially, if you're going out and you're saying, this is my partner, you guys are living together, there's sexual intimacy between the two of you, I think that's really when it starts.
Shanza?
You're living together, you're a couple. Everyone knows you're the couple. You are doing things that normally two people who are strangers or friends wouldn't naturally do. So anything that a natural observer would say a couple is like, I think if you're unsure, if you're a third person and you're observing two people, if you would call them a couple, then you probably are a couple.
Yeah, I think that line between dating and living as common law, that's where I think a lot of people will have those arguments. But if, I'm trying to decide, if a client comes to me and they're trying to figure out, well, did we start common law when we started dating when we were 15? Or were we common law, when we got a joint bank account together, when we rented an apartment together, when we started living together, when we started to make moves to really, like Joe said, intertwine our lives as if we're presenting like a married couple, even though we're not married.
What about the sock drawer? When you're sharing a sock drawer, is that enough, you think?
Like if your partner has a drawer at your place?
I don't know.
It could be, right? Like if you have two different apartments, for example, and every other weekend we go back and forth, you spend it at my place, I spend it at your place, and it's super consistent. It could be, because there are a lot of couples that are long distance.
Yeah.
A lot of marriages that are long distance. So I think it's really a fact by fact basis, and the courts would look at all of those different components, all of those different like milestones and kind of gauge from that.
I think I would take the approach of the late great Phil Epstein, who would always say at conferences, kind of tongue in cheek, but seriously at the same time, when the toothbrush shows up, you're common law, right? You got your toothbrush there, that's probably pretty good evidence you're living there, maybe not full time, but maybe you could be living there as common law. But it's sort of an interesting discussion because it makes you think, when does it flip from dating or friends with privileges to
Friends with privilege.
now I've got a legal obligation to this person and potentially children as well, right? So we're going to get into that a little bit more though.
Yeah, and sort of moving into how that can impact you, especially with property. Property is a massive component of the separation process. And unlike married spouses, where you have an automatic entitlement to the division of property, the sharing of assets, common law couples do not have that protection. So they're not legally required to split property acquired when they live together, when they were dating, or when they were together as common law. So, you know, furniture, household items, property, you know, laptops, things like that. Usually those types of things are divided based on ownership. Who owns them, who paid for them. But the common law couples, unlike married spouses, don't have the right to split the increase in value of property that you brought into the relationship, pensions, investments, all of those things. So if you contributed to property that your common law spouse owned, say they had a home, you were living together in that home, but you're not on title, technically you don't have any legal right under legislation for this property. You may have a right in equity to some of it. So unless your spouse agrees to pay you back for whether it's, you know, money that you put into renovations or money that you put into the mortgage, if you're not able to agree on that monetary compensation, you may have to go to court to seek that compensation. And what claim you would be bringing in court is called unjust enrichment. So it's to seek or address situations where one party has taken advantage of the resources of the other party to the detriment of that party. So there's really three core things that the courts look at. One, when trying to establish if there's an unjust enrichment claim. The first is there needs to be an enrichment. There needs to be something, whether it's money, a property, something that one spouse received that the other didn't. The other spouse had to have been deprived or suffered a loss because of it. So again, paying into the mortgage, but you're not benefiting from the value of that asset. Things like that. The third thing is that there's no legal reason for the enrichment. So the party who's receiving the benefit should be able to show why they should be allowed to keep it and not share it. You know, what was the intention? Was it a gift? Was it never meant to be a shared asset? Was it not a, you know, a family home? It was just some property up north that they never touched, never visited, anything like that. So all of those things is what the court would look at when determining if there's a claim for unjust enrichment. I mean, in a perfect world, disputes on property would be avoided, people could settle their issues, but that's not the case, especially with massive assets that, you know, say you were in a common law couple for 10, 20 years, that's a lot of time that someone could have put into property that their name isn't necessarily attached to. So that's why this unjust enrichment claim can be an effective way to address any unfair or unequitable situations involving property between common law couples. So that's in a nutshell. This could be, like we say every week, it could be a topic on its own, because even from unjust enrichment, you have so many different trust claims, constructive trust, joint family ventures. So unjust enrichment is like your starting point, but we really encourage, like, seek legal advice, understand what your rights may be, and it's really fact driven.
Yeah.
Well, I was gonna say it's a lot of stuff too, because, you know, all those sort of avenues that you were mentioning in terms of trying to resolve those issues and resolve those claims are, you mentioned equity. And I think sometimes people don't know the difference between something that's sort of a legal claim versus an equitable claim. And sort of what's really great about the law and common law in and of itself is that equity allows you to sort of not necessarily read between the lines, but it really deals with fairness and justice, and it's stuff that is not in established laws. And equity sort of allows, saves the day, exactly. It allows the judge to say, listen, you're in this position. The solution, maybe it's not fair, but is there a way to, you know, make it fair? And I think that's really great how we sort of have those two different systems that we can rely on.
I always think of that statue of justice.
Yeah,
Lady
Right,
Liberty,
so
Justice Liberty.
Yeah, so if the scales are not balanced and law isn't allowing you to balance them, you have this equity tool to kind of assist.
yeah, the property issues in Ontario go to the Ontario Superior Court of Justice. The Superior Court has what we have called inherent jurisdiction. So the judges have power to do justice and balance these scales. That's exactly what they're doing. They're going to equity and they're going to the common law. And they're doing what is right and what is fair, which is really the outcome of what we would hope for a justice system. But yeah, that's a great analysis. A couple quick questions that are coming in. Thank you, everybody. Keep the questions coming. They're fantastic. Do you have to live together to be in common law? Well, it's probably a good idea. There can be periods of time where you're not living together. How do you get awarded occupation rent? Wow, we spent a lot of time on this last week. And actually, I was at the Family Law Summit just a few days ago. And the consensus is occupation rent isn't quite as difficult as I originally thought. You get some evidence of what that home would rent for on the market. Perhaps a home would, the entire home might be $4,000. Your 1/2 share, that could be $2,000. Might be some issues as to whether or not you're a titled owner or not. Joint how title is being held. But get some evidence in terms of what the market will bear, calculate what your share would be, times it by the number of months you're out of the home, and make your claim. Good luck. And timelines to file the claim, yes. For unjust enrichment.
So,
Limitation periods, we're gonna get into that, so go ahead.
no, just say, we're gonna get into it.
Yeah, okay, but yes, there are timelines to go through, Blair.
Yeah.
Great questions.
Yeah, so that's sort of the property piece. Another question you get a lot of is, common law couples that have children together, but they're not married. How does being common law and dealing with all of the parenting and child support aspects that come from that, how does it impact common law? So Shanza, I'm gonna send it your way.
Sure. So when it comes to children, so that includes parenting time, there's decision-making responsibility. It doesn't really make a difference if you're married or common law. You have the same rights and same obligations as a married couple. The laws are the same for both. You're just under a different statute. So if you're common law, there's the Children's Law Reform Act, and that governs the parenting rights of common law spouses, not the Divorce Act. That's for married couples who get divorced. But really, your rights and responsibilities are the same. If you can't agree on an arrangement for parenting time and decision-making on your own, you can go to court for that. The courts will look at I know we've talked a lot about this, to look at the best interest of the children to make any parenting decisions. It's the same test that the court applies, regardless of if you're in the Divorce Act or the Children's Law Reform Act. The court will look at we went too many details, so I'll just give like a quick overview. So there's the children's needs, there's relationship with each parent, history of care, their preferences. The point overall is to do what's best for the child. In the same way, child support is still owed. It's the right of the child. Whether you're married or common law, you're still a parent. So essentially, if you're common law, if anyone in the audience is common law, they are separating, they're stopped living together, you need to figure out living arrangement for the children, parenting time for each parent, decision-making, child support, to come up with a parenting plan and make appropriate arrangements for the kids.
Yeah, I'm surprised in a sense. A lot of people will want a very creative solution when it comes to child support. And I think it's one of the hardest pill for the payor parent to swallow. But my ex and I, we agreed, no child support, no spousal support. We agreed. It's like, but the law says you can't. You have these obligations to the kids. You can't contract out of that. So I know we've said it a lot. I'm just going to say it again. If you haven't heard that before, that you can't contract out of child support.
Yeah. You know, for children in support, really, the rules are essentially the same game, whether you're married or common law. Best interests of the child are gonna dictate parenting issues, regardless of your marital status. Child support, go to guidelines, plug your number in, right? There's not a lot of wiggle room there. It doesn't matter if you're married or common law, you're paying support in accordance with guidelines based on your income and the number of children that you have.
Yeah, but what about, so that's child support?
Sorry, I'm gonna jump ahead, but we do have a question. What if I have children from a previous relationship and now I'm living with a current partner for some time? Will the current partner be responsible for my kids' child support?
Catching, you can collect child support from more than one parent, biological or otherwise. So the short answer to your question is you continue to collect child support from the bio parent. The new parent stands in loco parentis potentially to this child. So
Potentially.
they were playing mommy or daddy or whatever role they're playing, develop a relationship and a bond, and that creates a legal obligation to support that child. Your support may be potentially less than the guideline amount because there's also another parent paying for the same child. But yeah, you could be obligated to pay for children that you did not, are not your biological children, because you played the parent figure or some kind of role model in their lives. And simply because that parent's collecting support from a different biological parent doesn't let you off the hook. It may affect it, but I think that's a great question.
For sure.
Yeah, and keep sending them in, keep sending all your questions in. So shifting from child support to spousal support, a lot of people may think, well, I'm not married, how can I
Can't
get?
put a ring on it.
Didn't put a ring on it, don't get that spousal support, but Joe, what's spousal support look like from a common law perspective?
Yeah, so unfortunately, well, unfortunate to some, maybe good news to others, nothing really changes. We've talked about spousal support heavy in the past. I'll just give a quick little rundown. So spousal support, sometimes known as alimony, maintenance, other terms used. It's basically financial assistance paid by one person to another after a separation or divorce. And the purpose of that is help facilitate financial independence, so make each partner financially dependent on one another. Preventing financial hardship is another one, so that goes sort of back to the financial independence, as well as compensating for any financial disparities that occur during the relationship. And with respects to eligibility, entitlement to spousal support exists for married couples, as we said, but it also exists for common law. Those in Ontario that have lived together for 3 years, or individuals with a child from a relationship of some permanence. And that eligibility criteria does not change whether you're married or not married, and it involves demonstrating a financial need or a disadvantage resulting from the relationship, or in that sense, or if you have a legal agreement stipulating that support is given or needs to be given. And that can be either through a cohabitation agreement or a separation agreement. With respects to the process, so spousal support is not an automatic right, and it definitely is something that can be negotiated between the parties. And that can be through an agreement, or it can also be determined by a court. No agreement is reached, or an agreement is not existing. And the factors that are considered include income disparity, if there's any childcare responsibilities, the age of the parties, the age of children, health, and past roles that people have taken within the relationship itself. As for determining the amount, we always get that question: how much do I have to pay, or how much am I eligible to receive? Well, there are several factors that influence the amount that one's entitled to or one must pay. The big ones are income differences between the parties, childcare responsibilities, age, health, and self-sufficiency. So that's sort of going back to the factors as well as the process. there is something that we spoke about in detail a few weeks ago, and that is the Spousal Support Advisory Guidelines, short form for SAGs, as we call them. And they provide guidance, and legal professionals often rely on that to help assist them in calculating who owes what, or who's entitled to who's entitled to what, sorry. And although it's not necessarily law, these guidelines are heavily relied upon in the legal profession. So they're not really law, but they're law. And with respects to setting up spousal support, these arrangements can be established through, like I said earlier, through a separation agreement or a cohabitation agreement, which may be filed with the court for enforcement, as well. And alternatively, which is what we're here for, is that parties can litigate this in family court, and then a judge can issue a legally enforceable order for spousal support. So that's spousal support in a nutshell. We were heavy on that topic a couple weeks ago, but Spark Notes, it applies just as well to common law.
Yeah, and going back to those spousal support advisory guidelines, so they are advisory, like you said, it can give you goalposts on how much and how long. So I know we had a question come in about what determines the amount of time, or like the number of years, or how long spousal support is paid for. And Shanza, I think you talked about this the other week.
Yeah, and like Jill said, all the factors come in to determine the duration. I'm sorry, we can't give you a number of years here. I mean, I don't want to say it depends, but
The duration of the relationship plays a significant role. What also is determinative is if there's child support obligations also being paid. That affects quantum, so like the amount as well as duration. But it is a case by case basis.
Yeah, and another thing to bear in mind is the courts do have this rule of 65. So we talked about this a little bit the other week as well. So if the age of the recipient, so the person who's going to get support, plus the years that the parties were together, if those two numbers together equal 65 or older, support can be deemed indefinite. Strangely enough, indefinite doesn't mean forever, but it does mean for an unspecified duration of time. So that could be, up until there's a material change in circumstance, someone loses their job, someone gets injured and can't work, something significant changes. So definitely go speak to a lawyer, get independent legal advice, and they can help sort of understand the facts of your matter more, so that they can give you the tools to navigate how long you might be entitled to spousal support for, if there is entitlement there.
Yeah, I would take the same approach as if you're married, in the sense that the support guidelines are gonna apply to common law couples. So like Joseph said, you're gonna get ranges and factors that push it back and forth. Still ask yourself, is there entitlement? Right? That's the first question for every support claim. Is there entitlement before you go to the guidelines and these ranges? What I like to ask is there a need and ability to pay? This is the language of the Divorce Act, but it applies to common law couples. Do you need support? Right? Maybe you're making $200,000 and you don't need support. Is there an ability to pay? Does your spouse have an ability to pay? Your spouse is making $25,000. Unlikely there's going to be a strong support claim there, given how expensive it is to live in the province of Ontario. So there's some basic questions you want to start asking before you go down and pursue a support claim. If you have need, if the spouse has the ability to pay, you have entitlement, you know what the SAGs, the support guidelines are saying in the ranges, and it looks like there's a claim, talk to a lawyer and pursue it, right? It could be indefinite, like Steph says, it might be time limited. Depends on the length of the relationship, the role that you played during the relationship, whether there's children, your ability to re-enter the workforce, the skill set that you have. The question came in, that was a good one, thank you. What if my income goes up after this relationship? I think the short answer to that question is I don't think the spouse should share in that increase in income. Unless there's a relationship between your increase and the recipient's contribution to somehow make that connection. If you're simply just working harder, or you've taken on a second job, probably not. But if your pay went up because your spouse stayed at home and enabled you to hit this pinnacle of your career, could be a claim there. To use married couples language, we're looking at compensatory claims, but that's another hour for a different Tuesday.
Yeah.
But it's a great subject, great topic.
And like you said, I think people always, you know, they rush to the guidelines. Oh, like how much can I get? How much can I get? And it's, you know, you have to pass the eligibility and the entitlement. You have to see if you're eligible. And then people just think, oh, you know, it's maintenance, it's free money. It's not how it works. You have to be entitled. And that's what we're here for, to help you, whether you are entitled or you're not.
That's right.
Exactly.
And I'll also highlight that if like audience is going to SAG, I know it talks about the length of marriage and date of marriage. So if you're common law, you're kind of looking at the period of cohabitation. So it's interchangeable. Like for you, just replace length of marriage with period of cohabitation, because I know there's formulas there that kind of guide a little bit in terms of what you can expect. So yeah, that's my little.
I've got spouses who are entitled and have big claims, they don't want it. They lump sum it out, I'll take a lump sum, I don't want to be beholden to anybody, I want to be independent. So everybody's different.
Yeah, and that sort of actually flows right into our next sort of discussion point, which is how do you protect your rights if you are starting a common law relationship or you start living together? How can you protect your rights for, you know, the what ifs that you don't think or you don't plan you're going to have to encounter when you start your relationship? And how married couples we have my dog's in the office today, so we're looking around.
That's not what I was laughing at. I was laughing at that, you know, you're into this relationship, right? And you're already worried about protecting yourself, right? You know, this fantastic person that, you know, I have two beautiful young children, and you go, oh my God, I'm gonna start paying child support. Terrible way to enter into a relationship, right? But it's true, you want to protect yourself.
And I will say, I think that stigma that there is with prenuptial agreements, so marriage contracts or cohabitation agreements. I've had this conversation with like my parents and my grandma, and they're like, I would never. But from my perspective, I mean, of course, I see it every day. I work in family law. But the way that I look at it.
They're quite common for second marriages because they've already divided their stuff once and they don't want to do it again, right?
Oh, sure. Yeah. But I also think, like, best case, you put it in a drawer, you never have to look at it because you live happily ever after and you never separate. But worst case, if you do part ways, the worst case, like, you're still protected. Yeah. And I think that's how you know, when people ask me how I feel about marriage contracts, cohabitation agreements, that's where I always come from. But yeah, so this cohabitation agreement, because you're not getting married and you're just entering a common law relationship or you start living together, you still have the ability to protect those rights, whether it's property, future spousal support entitlement, you know, who will move out of the home if you part ways. Does one spouse own the home and they want to protect that home from a unjust enrichment claim? Do they jointly own a home but they're not married? How is it going to be? Is it going to be sold when they separate? Are you going to one person buy the other out? So all of these questions that you would traditionally have at the breakdown of a relationship, if you ask yourself those when you're entering into it, it can all be detailed in a cohabitation agreement. So to make sure that's all binding and legal and you're protecting yourself, of course, we always recommend that you get independent legal advice and that both partners have independent legal advice. But once your cohabitation agreement is finalized, it's drafted to the way that both parties agree. You sign it, you date it, you have a witness sign it, and also if you have independent legal advice, your lawyer can provide a certificate. So a cohabitation agreement can't say if you will pay child support or what parenting arrangements are gonna happen for the kids, because one, there might not be kids at all at the moment. But that sort of, analysis is done at the time of separation. What's the best interest of the child, right?
Mhm.
You can't really predict that 10 years into the future, so that's just one of the things, one of the components that can't be included in a cohabitation agreement. But if you want, and you both have independent legal advice and it adheres to your wishes, you're signing it freely and voluntarily, you're not being coerced, you have financial disclosure, you could waive your entitlement to spousal support. Right, so that's something, you're both adults, as long as you, like I said, have the information necessary and full and transparent disclosure. You can really contract in any way you want, and I think you've said it best, you know, you can make a bad deal, but our responsibility as counsel is to tell you why it's a bad deal and provide our recommendations on how to improve the deal and how to protect you.
Clients can make bad deals all the time, but as long as they're making an informed bad deal. Some great questions coming in. Income amounts don't affect entitlement. Just because somebody's in a couple million and you're 500,000 or whatever the number is, that doesn't go to entitlement. Yes, you can receive $250,000 or $500,000, still be entitled to support because the other income is so much greater and it's a lifestyle issue. Dogs and pets are important. In Ontario, it's a very cold analysis. Who owns this item, like a piece of furniture? Where's the receipt? And that's going to dictate the outcome. And if you need to get an order to enforce that, that's, you need to go to court. Yeah. It's determined by ownership, and BC's got some pet legislation that's coming. It's very popular. It's not coming to Ontario, at least at this point. Question about retroactive pay. You can do a retroactive adjustment to support if it came in later. I'm wondering if it'd be cleaner just to deal with it going forward in terms of you may have been entitled to receive it 3 years ago, but you got it in this tax year. So you need to think it through in terms of the cleanest way to deal with that issue. But great questions coming in. Thank you so much.
Also, just because you sign a co-hab agreement doesn't mean you can't get married. That co-hab agreement can turn up to a prenup. Very easy.
Yeah.
We'll have agreement to a marriage contract, absolutely.
Yeah.
And I want to distinguish between making a bad deal.
Yeah.
And being misled, right?
Yes, very different.
There's non-disclosure. Somebody didn't tell you about an asset. Those agreements are quite often set aside. The closer you get to a wedding date, the more likely that agreement is going to be set aside.
Yeah.
So if you negotiate the marriage contract 18 months ahead of time with independent legal advice and full disclosure, you have a chance. You wait 2 weeks outside of the wedding and the guest list has been set, it's going to be a problem. You do it the day before the wedding, you know, the bride's got her dress ready to roll, you know, you got to question whether or not there's some duress there and whether that agreement is enforceable.
I think the rule of thumb is like what, 6 months before they're good.
I think that's a good,
Yeah.
but if sooner, I mean,
Yeah, for
the
sure.
sooner the better, obviously, like the more distance
Yeah.
out, the better, but I've heard of some, you know, there's always a possibility to take, instead of doing a prenuptial agreement, I know we're sort of touching on married spouses again, but you can do a post-nut, but those are fairly.
Domestic agreements can apply to common law couples too, right?
Exactly. Here. You want to enter into a cohabitation agreement to protect this asset that you've been living in.
Right.
You could still do that, as long as, like Russ said, those kind of hallmarks are.
Or you're gonna receive an inheritance and you don't want common law spouse making an unjust enrichment claim against an asset that you buy with that. You want to protect it. So you can make bad deals, but bad deals done improperly will be set aside. A good chance they'll be set aside.
And with pensions, if it's possible to split.
Last one.
Oh my, we're researching this today. Stay tuned. I'm going to talk about it in a few minutes. When I say we were researching it, I mean, Joseph was researching.
I would, it's been a good couple of morning, but I know we have.
We found it, we've got your 13 question
We found it.
and the leading case, well, not leading case.
So teaser there, but Joe, I am gonna ask you, so we talked about perhaps. But what about separation agreements? Is it different for common law spouses as opposed to married spouses? What's the process look like for them?
Yeah, so with respects to the separation process, I'm just gonna go through the steps. It is very similar, if not almost identical to those who are married and they're going through a separation. The only difference would be is that you're not applying for divorce because you were married. So steps, what are the steps that most people take, regardless even common law or the breakdown of the marriage occurs? Having that informal discussion. So having that open, honest conversation with your partner about separating, determining a date of separation. We've talked in the past how important and crucial the actual date of separation is. We won't go into too much with that today. And also when you're having this, that conversation, discuss the practical aspects of, living arrangements. Who's going to live where, financial support if necessary, and if you have children, what parenting arrangements, are most comfortable and most effective and efficient with your situation. Next, we would recommend starting to gather necessary documents. What does that mean? So that can be collecting important documents relating to your relationship, such as leases, joint bank account statements, or any agreements you may have made together, as well as your tax returns. Usually we ask for the last 3 years in terms of financial disclosure. And then once you have that, we would highly recommend that you have a consultation with a lawyer. So it's really important to seek legal advice from a family lawyer to understand your rights, your obligations, if you have any, regarding property division, support, parenting arrangements, all that kind of stuff. Then once you do have that consultation with a lawyer, it'll be through counsel, through yourself if you don't obtain counsel. But this is sort of the negotiation stage. It's really important to try to attempt to negotiate separation terms with your partner, either directly or through even mediation. There's a lot of great free mediation services that are offered. And like I said earlier, this can also be done through the assistance of counsel. Being able to keep it out of court really allows you to have more control over your matter and the terms that you want to include. And when I say include, it means that ideally you would create a separation agreement. And if you're able to, reach an agreement, either through mediation or through negotiation in and of itself, you would ideally want to formalize them in a separation agreement. And like we go back, that would include details on property division, any support payments, the parenting arrangement, or any other relevant matters. And it's also really important that you want to ensure that the agreement adheres to Ontario family law requirements. You're not just pulling something off the web and you're doing copying and pasting. Oftentimes, it's not going to be a document that can be relied upon later on. Steph spoke about it earlier, and we can't emphasize this enough, but it's extremely important that people obtain independent legal advice. Even if you don't consult a lawyer previously and you want to take it upon yourself to draft this agreement, do not sign it without getting independent legal advice. Each of you should seek your own independent legal advice. You can't have your own lawyers. I'm sorry, you can't have the same lawyer. You need to have, your own lawyers. And do this before you sign the agreement. And if both parties have their own lawyers that help draft the agreement, that's even better. And that basically ensures that both parties, once again, know their rights, know their obligations, and that the agreement is fair and legally binding. Once you do that, you're going to execute the agreement, and then, like I said, optionally, you can file it with the court. This just is for enforcement purposes. And then once that's done, closure, moving forward, obviously you want to adhere to the terms of the agreement. And then it's really important too that both parties stay open to revisiting that agreement because things are going to change, circumstances are going to come up. So obviously, ideally, we talked about it previously, but you're going to have those dispute resolution clauses in the separation agreement. You want to plan for, any circumstances or changes that happen in the future. That could be changes in income, or any child-related needs, so it's really important to have an open mind and be ready and able to revisit the agreement.
What about this document my friend found for me on the internet? Can I use that?
Don't use it. You know, we have the term, it's coined kitchen table. And that's sort of what it is. You and your spouse or you and your partner sit at a table and you just draft it on a piece of paper, or you might go online, you might Google, you know, separation agreement and take bits and pieces from that and think that it applies to your situation. Those get overturned.
Very dangerous, yeah.
Very, very dangerous. They got overturned. And then if you think you have a good deal, or you maybe think everything's said and done, that can just be ripped, thrown in the garbage by a judge. And
After 18 months of litigation.
Yeah,
yeah,
dollars in court, fees later
Right,
in court. Yeah.
always better to do it the right way first, and that is consulting a family law lawyer and having them negotiate on your behalf and helping draft the agreement.
Some rapid fire questions coming in here, thank you. Forcing the sale of jointly held property, bring an action pursuant to the Partition and Sale Act. You can get that property sold. We're gonna talk about people dying in a moment with or without a will. How long can you, after separation, go to court? Yes, there's gonna be a limitation period if you wanna get a portion of the home that you own. So you wanna get on that, but what's that take us to, this morbid topic you assigned me or what?
That's the topic of estate rights, because no one else.
Okay.
But yeah, so what does happen if there's a common law
Right.
spouse and they
Oh,
pass?
in Ontario, the Succession Law Reform Act, this is your legislation. You die and there's a properly executed will, you're gonna follow the provisions of that will. There was a question about disputing a will, you need to see a state's lawyer and make sure. I'm not sure what the basis of the dispute would be, maybe it wasn't properly executed or the person didn't have capacity. If you're a common law partner and there's no will, you're legally in a vulnerable position. You need to make a dependence claim against that estate. There could be competing dependence claims, other spouses, other children. Maybe your spouse wasn't unmarried or divorced from the first wife or husband. That person could take a spot in your life. It's a tough spot to be in. Certainly, dependence claim is going to result in litigation. There's no guarantee as to how much you're going to get. And state litigation, like family litigation, can take some time, sometimes even longer. So get a proper will in place is the point of what I'm saying for both you and your spouse if you're common law. Don't leave it up to the legislation. It's gonna get expensive.
And not even the legislation, you know, common law spouses, as we said, do not have an inherent right to property.
That's right.
So I think as a common law, you're only entitled to be the administrator of the estate, which doesn't really help. But
Yeah,
you definitely need to make sure that either you're accounted for in the will and vice versa with both parties.
And almost, you know, it's pretty standard for most, if not all, conversations that we have with clients when they are separating. Update your will, because the process to finalize a separation agreement, it can take time. The process to get divorced for married couples can take time. So when you know that you're separating, there's no chance of reconciliation, make sure you update your will to reflect what your wishes are. Yeah, estate litigation can
and
be.
your wishes might not change, or you may have a new partner and the property goes somewhere else.
Exactly,
How
so,
about insurance beneficiaries?
Alright,
Insurance beneficiaries, when you have, or you don't have someone listed as a beneficiary in terms of an insurance payout.
right, it's probably gonna be litigated in your estate as well, so that's a great point, Joseph.
yeah. So when you have an agreement, whether it's cohabitation, separation, And something like Joseph mentioned, something in the future comes up that you either weren't expecting, there's been a change, you have to revisit the agreement. What can you do? Do you run to court? Is there other ways to handle it that are more amicable? Shanza, I'll send it off to you.
And, you know, in all our sessions, we talk about ADR, which is dispute resolution outside of court. And I think we try to keep selling it because going to court is not easy. It's not easy, it's not the best route, it's expensive, it's stressful, and I think anyone out there, everyone should try to settle outside of court before you consider court as an avenue. And even if you find yourself in court already, it's not too late to try to settle outside of court. I know this can be a little confusing because sometimes people are like, oh, we're in court, you know, there's too much conflict. But as you progress through court, you might find ways, you might find windows where you're like, oh, maybe this can be settled outside of court, right? And when we talk about outside of court, we're talking about mediation, arbitration, collaborative law. And in these instances, instead of going to court, you're kind of working with a neutral third party, or in the case of collaborative, you're working with a team of professionals. And this third party, they'll help you guide towards a mutual solution. If you're in mediation, there's family mediators, they guide the process, they help you negotiate. And at the end of the mediation, you can reach an agreement, which if you sign it, you can enter into an agreement and it can become binding. There's also arbitration. Arbitration gives similar benefits to mediation. It's different because the arbitrator's decision, it can be legally binding, but it's still different than going to court. It can be faster and you have more control on how the proceedings are run, but the arbitrator still has the final say. And in terms of, I know I was talking about parenting earlier. So if a great thing about dispute resolution is if you are going to be co-parents in the future, dispute resolution and being able to communicate can give that foundation to you to be able to co-parent effectively in the future, right? And yeah, so in the sense of if you're common law, I know we're talking about common law today. So for common law, you can go to ADR for any issue, child support, parenting, decision making, spousal, property. It's always great being a lawyer and preaching don't go to court. That's what we preach, because that's the highway.
Or collaborative practice, right? Done that in
You
court.
can still use lawyers in an out of court setting, so you still have the assistance of the lawyer.
You still have the expertise.
That's right.
You are settling it in more control in a less stressful environment.
You have a third party telling you how to live your life or when you're gonna see your children.
Yeah, 100%. And I think, Shanza, you really hit it on the head. A lot of people think once you file in court, that's it. We have to go to court. But you know, what happens if there's parenting issues, there's support issues. We can agree on parenting, but for some reason you just can't meet on support. Well, you can mediate, you can negotiate, you can enter into a consent about the things that you do agree with, and that you can compromise or come, you know, to a resolution on, and then leave the one or two issues that you just cannot reach, you cannot figure out. You can leave that to court or leave that to a judge at a conference to help facilitate that discussion. So I think did you have not a CPD or something on that too, but the runaway train,
Oh, yeah.
taking matters that are headed for litigation, how to take them off of that track.
Or they've been in litigation for 2 years. And this is so sad, because it's story time. This is that time of night, right? I get these clients who come in new to the firm, but have been litigating for 2 years. And to tell me what's going on, it's terrible. Blowing thousands of dollars of money down the drain that could be used for their children's education. And so I'm trying to understand, well, what's the conflict here? It's high conflict, yeah, okay, I get it, but what is so special about your family that you need a judge to determine this outcome? 9 out of 10 times, there's nothing. right? You can resolve it collaboratively if you work together. So I explained to these potential clients what collaborative practice is. We focus on goals and interests. What's important to you? What's important to your family? And we structure the agreement according to that. Every parent I've met has always said the children are the most important thing. Every time. Not once have they said my kids aren't important. So right off the bat, you're working on the same page. You go see a regular lawyer with their collaborative practice training, they do a rights-based analysis. So you tell me your facts, I'll tell you this is what you're entitled to receive, let's go get them, let's do this and that. You know, we talk about advocates and warriors and peacemakers and firefighters. It's sort of this analysis, right? So instead of doing this rights-based analysis that got into 2 years of litigation, your case is still not over. Let's talk about goals and interests and what's important to your family. You're going to structure an agreement that works for everybody. And when I say this, the client says, well, nobody told me that was an option. Had I known that 2 years ago, I would have saved $50,000. My children might still be talking to me. I guess it's heartbreaking, right?
Yeah.
Like this is, anyway. So because there are so many of these people stuff that I met, we created this program called Runaway Training, getting high conflict court cases out of the court system and resolving them collaboratively. And it's been very effective. People just, they need to see the light. Nobody told them this was an option. And had they known, they may have taken that track earlier and ended up in a resolution. But you asked the question. I wasn't going to get going, but you got me going.
I did ask the question, but Russ, I am actually going to come back to you. We
All right.
had this user for a pension question earlier tonight. So what are some key court cases or some legal precedents that have shaped common law rights in Ontario?
Holy cow. All right. The title of today's program is Legal Rights of Common Law Couples. So I just want to do a little bit of background and then I'm going to give you my text.
Okay.
Do you have your permission?
Go ahead.
Okay. So we're talking a lot about trust claims. And Joseph touched upon this. This is just a fancy way for lawyers to say, we're going to share stuff. Okay. You've got stuff. Right? Maybe somebody's got the house in their name, but you contributed to that house. So we want to share stuff. But your common law, you don't have property rights. So how are you going to do that, right? So just to jump ahead a bit, 2010, there's a big push to amend the Family Law Act so common law couples enjoy the same property rights as married couples. That didn't go anywhere. So the court's kind of been stepping in and doing justice, you know, this conversation we had. Okay, so we're going to share stuff and we're going to give it a fancy name. So we're going to create trust arguments. So your common law partner, you're going to make a trust claim against an asset of some sort. The main asset we would only see would be the home. That's usually people's biggest asset. Pensions we're going to get to. I'm excited about this one too. Okay. So what are my Steph did a great job talking about enrichment and deprivation and imbalance. She did a great analysis. So your remedies are a constructive trust, meaning I contributed my labor, I contributed my time, I made improvements to this home. So I've got a constructive trust claim to this asset. Another remedy is called a resulting trust. All right, you bought this home, but I gave you 10 grand and you put that money as a down payment. Or I paid money to get that kitchen renovated. And I can trace that money coming out of my account going into this home. That's a resulting trust claim. All right, those are the main branches. So that's sort of just the teaser to talk about case law. There's thousands of cases on this. I'm going to talk about 4. Because I think this will help give us the parameters of what we're looking at. Number 1, Becker v. Petakis, Petkus, 1980 Supreme Court of Canada. This is where this idea of constructive trust comes into play by the Supreme Court. We talk about superior courts with inherent jurisdiction, the right to do justice. So this is the court's authority to make up outcomes that are not permitted by the legislation. Essentially, they're doing what the judge is going to do what he or she thinks is it needs to be done to come up with a correct result. Number 2, MVH 1999 Supreme Court of Canada. So this was important because it recognized the rights of same-sex partners living in a common law relationship. Right? It wasn't too long ago, it's common today, but this was groundbreaking. So now same-sex partners can make these claims that we've been talking about for the last hour against each other to try to come up with the correct result. And the courts recognized simply because you're a same-sex couple, you enjoy the same rights as heterosexual or other common law couples. Third decision that I think everybody should read, not that you're going to read it, if you can't sleep, you're going to read it. All these Supreme Court decisions are hundreds of pages, maybe thousands of pages if we put them all together. Herbert v. Burnanow, Baranow, 2011, Supreme Court of Canada. So we had trust arguments from earlier on, right, that I talked about. Now the courts come up with something called a joint family venture. So you had constructive trust, made improvements, resulting trust, paid money, I can trace it. Now we got a joint family venture. That's exciting, right? Like we're gonna go
The evolution.
we're gonna load up the station wagon and go on a trip, right? So basically you're a common law couple. You've got this plan that you're gonna live jointly and create this family unit. And this joint family venture and evidence of it, there's lots of ways you can get evidence, family holidays, where you present yourself to the community, church activities, tax returns, lots of ways the evidence can come in. This is another basis to form a trust claim. So it doesn't necessarily mean that you had to put $100,000 in the home and get a claim out of it. It's a joint family venture. We need to share your stuff, right? For lack of a better term. So just a quick story on this. I had a case where my client was sort of a director of a cruise ship, the activities or the trivia nights or whatever. Her common law husband was the captain of this ship. And they lived together in captain's quarters for a period of time. She also had her own cabin. And this went on for a few years, and then they separated. And she makes her claim, and I represent her, and he's saying, oh, no, we're just dating, and she had her own cabin, and this and that, right? So how are we going to prove this? They were a common law couple. Well, these ships have newsletters. And the newsletters had them presenting themselves as a couple and doing this and that. They own property internationally. She owned land here in Ontario, which gave Ontario jurisdiction to deal with the matter. The ship's traveling everywhere, right? I think he was from England, and he could have commenced. It's lots of interesting legal arguments. End of the day, Ontario took jurisdiction. We pursued the common law claim successfully, looking at these hallmarks of whether a relationship or a joint family venture is occurring. But you can see how interesting these cases can get when you start digging into it.
It's just like the evidence that you used to show there was a common law was so unorthodox, and there was questions. Oh, what if we don't have bank statements? Why don't have this? Like there's something. Whether it's text messages, whether it's maybe someone's Facebook post or just anything, it can really be anything.
Friends and family can testify, right?
And these days with social media, like there's no escaping it.
Oh yeah, listen to this. Somebody was getting cute with us one day, and we're deleting posts and this and that. So you can get an order from the court directing Facebook to export everybody's social media posts and every site they've been to.
Just because you delete it, I mean, it's
Facebook still has it, right?
Yeah.
So what's great is we had the evidence that they had presented, most of which was deleted, and then we had the raw data from Meta to compare the two. And it was clear people were up to mischief. Fourth and final case, thank you, Joseph, for finding this. I remember coming across it, but I couldn't remember the name. Madam Justice Hughes, it's the case of Hughes versus Visante, common law couple dealing with pensions. Second largest asset usually couples have. Forever, I would say pensions are not subject to common law. Because if you think about it, where's the deprivation? I'm getting this pension. You know, my spouse is not out of pocket anything, right? Where's the enrichment? I'm not getting enriched. I'm worked for the pension, right? So this basic analysis of enrichment and deprivation, I didn't think the court would get over the hurdle. There was procedural issues. That particular party wasn't complying with an order, is going by way of a Rule 23 hearing, which means it's a fancy way of saying he wasn't permitted to participate. And I think the court was just so frustrated with this litigant, they just ordered the pension to be divided. I don't know if it's correct law, but it's on the books. You want to divide a pension, you've got a case that's going to support you. So we could talk a day about case law that affects common law rights and responsibilities. But I think these four give a nice flavor in terms of the parameters and how you can even see the evolution of the court in terms of expanding the claims to include same-sex couples, to come up with this idea of joint family venture, to capture claims that weren't being captured purely by constructive trust arguments. And but that's my take. What do you guys think?
I agree with you. I think the fact that, especially that pension case was uncontested, so it wasn't a back and forth. It wasn't a judge hearing both sides. They're only hearing from the person pursuing the claim. But that's not to say that the joint family venture and these trust remedies aren't utilized, especially for couples where one, even though they're not married, one spouse stayed home with the kids and the other was sort of the main breadwinner. Well, the spouse that was a stay-at-home parent, maybe they don't have any education, they didn't have the opportunity to pursue you know, their career, they don't have the funds to put into the matrimonial home, or sorry, not the matrimonial home, but the joint home, the family unit home. So we see a lot of stay-at-home parents or parents where they took that role utilizing these trust claims.
Right.
And that was the argument, right?
Yeah.
The argument was the joint family venture, and that she stayed at home with the children, didn't work. She put her career aside so that her husband, who was working at the Toronto School Board, would get the pension. And then that's how, that was her ruling. That was Justice Kraft's ruling.
Yeah.
So Shanza, I'm just gonna rapid fire to you. We talked a lot about a lot of different things. So why is it essential for common law couples to seek independent legal advice, to get, you know, the help of a lawyer?
Yeah. Sorry. So I think we've talked about, like, this whole hour, we've covered so many different things, right? When it comes to common law, there's different rights and obligations. There's support, there's parenting, there's property, even though there's no equalization, but Russ just gave us an overview of all the different type of remedies that you can seek, right? And these remedies make it obvious that when it comes to common law, the rights are not as clear-cut as if you were married. And that's the beauty of our legal system, right? You don't know what's going to happen. But that's the reason why it's so much more important when you're common law to get that legal advice, because you don't know if you're entitled to a claim, or if you are, is it a strong claim? Is it not a strong claim? Is it worth pursuing? If you have a lawyer that you can talk to, that you can speak to, they can guide you. And I know, Russ, you were talking about this. Know your rights. At the end of the day, you can decide to enter into an agreement, or you can decide to let go of your rights. But do it, you make an informed decision, right? There's a difference between entering into an agreement that's not in your favor, that was made using an informed decision, versus one where you didn't talk to a lawyer, where you could have spoken to a lawyer and they could have guided you in terms of what are the remedies that are available to you. Especially under common law, you don't know what you can get. there's a lot of variable, so speak to a lawyer.
Thanks, Shanza, and we touched on a lot.
Very good.
And we did mention at the start of all this.
I did talk about pension.
But
I
did
did talk, I answered the pension question.
ticked off. I just want to thank everyone for tuning in. Thank you for your patience with the sound and how we're doing. You know, that we call them owls because they're like a 360 camera. Thank you so much. Following the session, once the webinar closes, a brief survey will pop up. If you could just fill that out, let us know your thoughts, what you like, topics you want to hear us discuss. Your feedback is always greatly appreciated, and thank you to everyone who participated and sent in your questions. It makes it really fun for us to sort of rapid fire and to really share what the people want to hear. And as I mentioned earlier in the show, there is an opportunity for you to snag a 20-minute a free meeting with one of the lawyers at our office for up to 20 minutes. So if you do want to take advantage of this opportunity, make sure to register by noon this Friday. And when scheduling your appointment, we're going to ask that you provide the code STEP 2024 to our intake department, Nicole. So I'm just going to type that in the chat. So that is STEP with a PH to Nicole at our intake department, and she'll be able to coordinate when you can have that free 20-minute meeting with a lawyer. And that's everything for today. Thank you to everyone again. Thank you. It's really fun to do this in office.
Yeah.
So,
Yeah.
And we're gonna work on improving our sound.
we
but
will.
This is, we're live streaming to YouTube. Thank you, everybody on YouTube watching tonight. And what a great night. There's so much covered off. It's so helpful. Thank you so much, everybody.
Really good. Thanks everyone for tuning in.
All right.
Okay.
It's interesting to not have the shutters.
Yeah.